Gross abuse of office by A, directing the MERU Teaching and Referral Hospital to spend all revenue at source, whereas all monies raised or received by or on behalf of the county should be paid into the county revenue fund. B, issuing waivers on fees at the MERU Teaching and Referral Hospital, whereas the county executive committee member for finance is the only person legally empowered to grant such waivers. And C, directing county government officers to participate in furthering and advancing the interests of Baite TV, a media station owned by Mwangaza Advertising Limited, a private company owned by the governor through her close proxies and relatives. Honorable Governor, to that charge, do you plead guilty or not guilty?
Not guilty.
The last charge, misconduct relating to nomination of county executive committee members. On or around the 8th day of November 2022, the governor engaged in 1, gross misconduct, 2, grossly violated Articles 10, 73, and 75 of the Constitution, 3, grossly violated Section 10(1) of the Public Appointments, County Assemblies Approval Act 2017, and 4, grossly violated Sections 3, 4, 10, and 11 of the MERU County Retention Enhancement Fund Act 2016 by A, vilifying members of the Assembly for refusing to approve some county executive committee nominees at a public rally held at Kiangoi in Igoji West Ward. B, falsely accusing members of the Assembly of shortchanging Kasti Misheni and other nominees for the appointment to the CEC. C, illegally instructing Kasti Misheni to usurp the statutory functions of the Igoji West Ward Retention Enhancement Fund Committee by identifying the persons that would benefit from county bursary funds. D, failing to submit names of other candidates to the County Assembly for approval for appointment to the CEC after the Assembly rejected some nominees. E, reorganizing her government to 6 departments and 3 CEC members after the rejection of some nominees instead of submitting names of other candidates to the County Assembly for approval. And F, swearing to appoint to her government and actively work with losers of the 2022 county elections instead of duly electing MCAs to star wrangles within the Assembly. Honorable Governor, do you plead guilty or not guilty?
Not guilty.
Chair and members, this is a verbatim recital of the charges as presented by the County Assembly.
Thank you very much. Your Excellency, we thank you. You may now resume your seat. You be seated. Thank you very much. Honorable members, before we start listening to evidence, I would like us to do a bit of housekeeping. There might be preliminary issues that parties would wish to raise. This is the time. I therefore want to invite the County Assembly of MERU to raise preliminary issues, if any.
Honorable Chair and members, on behalf of the Assembly, we have no preliminary issue. We shall crave your leave to address any if they are raised by the other side.
It's granted. I now invite the Governor of MERU to raise preliminary issues, if any.
Thank you, Chairman. We have one preliminary issue by way of housekeeping. We were served with a motion of impeachment together with the witness statements. we discovered that some of the witness statements that were served on us at the Senate hearing were not part of the witness statements that featured before the County Assembly. It therefore became necessary, and to redeem time, we elected to, one, file a supplementary affidavit, which we have already filed and served on our counterparts. They have not raised any objection to our filing, so that to bring into perspective the case of the governor of Meru County. The other issue, we realized that in the bundle of the documents supporting the response of the governor, we had omitted 3 affidavits, which we have already supplied by way of the supplementary affidavit I've referred to. This is the supplementary affidavit sworn on 26th of December, 2022. It was sworn by one Harrison Gatombu. Honorable Chairman, I would crave the leave of this court that you allow us to file that supplementary affidavit outside the stipulated time that was stipulated in our invitation, and the already filed and served supplementary affidavit to be deemed as properly filed and served. And Your Honorable Chairman, we are not going to dislocate any part of the hearing by allowing that supplementary affidavit, and we are not going to inconvenience this committee or our counterpart. We pray, Honorable Chairman, to allow us to admit that supplementary affidavit.
Thank you.
Chairman, I kindly seek you allow my learned friend, Mr. Mutuma, to raise something.
Thank you, Mr. Chair. Additionally, we also realized that while we were trying to beat the deadline, we omitted to include one video that forms part of our record and evidence. That video is mentioned in our affidavit, but it was omitted. It was not uploaded in the flash disk. We have already supplied it through email to council representing a county assembly. We have also shared the same with the secretariat. We beg that the same be admitted, and we are allowed to use the same. Thank you.
Welcome. Very well. Now, County Assembly, you've heard. Do you have anything to say?
Yes, Honorable Chair and Senators, we strenuously oppose that request because what they are trying to do is to bring evidence by way of ambush. The rules of this House are very clear. They were given an opportunity to file those documents. Why it is an ambush, Chair, they are asking you to allow them to put in 4 affidavits, 5 videos, and 3 exhibits. Why it is an ambush is we will spend the whole of today before you, and tomorrow is their day. When shall we have the time to study that additional material, and if necessary, file our response to it? So our ground number 1 for objection, Chair, is that it is an ambush. Number 2, ordinarily, because there is a quasi-judicial procedure, a party seeking to introduce new material must persuade you that the material in question could not, with due diligence, have been filed within the time given. And time permitting, I will show you why all the material they now seek to bring after the horse is bolted was material within their possession. It was material which, with due diligence, they would have brought in within the timelines. We are also telling you they have not been diligent because on the record before you, this additional material, together with the material they have already placed before you within the time, is material that ought to have been placed in the first instance before the county assembly. On the record, the governor was given 7 days to file a response before the county assembly. She did not avail herself of that opportunity. So that as we speak, Chair, even the material filed on time, we are seeing it for the first time when, under the rules, that material ought to have been placed before the county assembly. It was not. Number 4, we are hoping we will persuade you that even when you read the proposed new material on its face, there is nothing in it that would justify the request now being made. And our 5th objection is that this is part of the ploy, Chair, knowing how packed and time-bound these proceedings are, to eat into so much of today's time through preliminary issues, knowing very well, of course, that the time to be eaten is the one my team would normally use. Chair, why do we raise all these things? They tell you casually, they sent these things by email. What they don't tell you is that that email was sent at 5:24 p.m. yesterday. Yesterday was Boxing Day, but even if it were a working day, 5:24 p.m. As a matter of fact, Chair, we have only seen that email today morning while wrapping our bundles to come to today's session. And when we saw it, Chair, among the 5 things they're asking you to, one of the things we hope you'll note if you're familiar with the documents they hope to introduce, is that they are telling you in their proposed additional affidavit by Gatobu Mudhuri at paragraph 4, that these videos that they propose to introduce, they are videos they have edited. They tell you that in paragraph number 4, number 7, number 8, number 9, and number 10. He's telling you, I edited these videos by adding captions, and he's also admitting to you that the same captions he put are erroneous. That's why now he needs to put correct captions. The question, Chair, is, based on that deposition where the person requesting is already admitting to you in black and white that the reason they want to bring this new evidence is because they edited the videos they brought to you within time. So for that reason, Chair, we say that affidavit by Patrick Gatobu would not be admissible. There is another one by Harrison Gatobu. These are 2 Gatobus, Chair. It's a different person. One is Harrison, the other one is Patrick. He's telling you, when you read his affidavit, that he is the chief of staff of the governor and that he is aware of all the allegations under charge number 1. He is aware of the circumstances, and therefore, he should be allowed to put in this additional affidavit. Chair, I urge you, like everyone in the room, to know that the person who would be competent to speak to county appointments is not the governor's chief of staff. It is the secretary of the county public service board. Failing that, it will be the county secretary. So the man now purporting to ask you to introduce additional evidence by way of an affidavit is not the man in law who is qualified to speak to the matters he proposes to speak to, and of course he goes on to tell you many other things. He tells you some documents were inadvertently omitted and whatnot and whatnot. Chair, if you go to that affidavit they propose to put, it is by a gentleman called Edward Bundi Jeffrey. They are telling you the reason they want to put this document is because this gentleman put before you an affidavit that was not signed, an affidavit that was not commissioned by a commissioner for oaths, and because he forgot to do that, which is lack of due diligence, he's asking you, the committee should allow him. They have a further affidavit by a gentleman called Samuel Mwenda, same reasons, no ground given. The annexures they propose to put you, one of them is an annexure about an invitation letter, which is already in the governor's response as filed. So we don't know, and in any event, this annexure should have been put before the county assembly in the first instance. They had their whole 7 days to do that. They chose not to. Lastly, they propose to put before you a document that is 9 pages, which is the speech given by the governor on 19th October 2022. 19 October 2022 was about 6 weeks before the impeachment. So the governor was always in possession of that document. The million-dollar question is, why wasn't it put before the assembly? And why wasn't it put before you on time? For those very many reasons, Chair, and I really regret we are taking more of the time we should be doing the case, we beseech you that they have not laid out a good reason for the request they make before you. In the event, Chair, we are unable to persuade you to reject this request, in the event the House grants the request, we crave that you similarly allow us a request to also put our additional documents in response to this additional material, because at any rate, it's a trial. What is good for the goose should be good for the gander. Thank you, Chair.
Very well, you're most welcome. Allow me to allay your fears that the governor's team is eating into your time. No. We have carefully budgeted for time. There is time for preliminary, and we are still within that space.
Chair, with your permission.
Chair, a brief rejoinder, with your permission.
Yes, Governor.
Thank you, Chair, for the opportunity. The proceedings before you, Chair, are quasi-judicial in nature. The committee is sitting having the same powers as a court of law. And in doing that, the committee is called upon to uphold Article 49 and 50 of the Constitution by granting the governor, who is equivalent to an accused person, the right to a fair hearing. That right to a fair hearing, Honorable Chair, entails the right to produce any materials that she feels are necessary for the tribunal's consideration to assist in her defense. I do not know why the County Assembly is afraid of these materials being introduced, because they will assist in the tribunal reaching a fair hearing. It is only fair that all materials are presented before you. Honorable Chair, I have had an occasion to look at the standing orders and the rules governing these proceedings. Rule 20 bars the County Assembly from introducing any new material or evidence that was not previously relied upon during the impeachment proceedings at the County Assembly. My learned friend, Mr. Dr. Yankolu, has not denied that the 4 witness statements One by DMK, the mover of the motion, another one by Mwenda Idhili, another one by Lucy Mokaria, and Father Elias Kenoti, were not presented during the impeachment motion at the county assembly. So
yeah, that's a distortion of your rules. In the county assembly, there is no room for witness statements. Those witness statements were filed before you pursuant to your standing orders requiring us to file the witness statements. So us being accused of sneaking in the witness statement is really unfair because we were only obeying the rules of the Senate. There are no similar rules at the county assembly.
Council, don't run the risk of annoying members of this special committee. Be composed. Listen to your counterpart. When it's done, ask for time. We'll give you to respond.
I'm guided, Chair. I was only interjecting because that's how we do it in High Court. I'm really sorry. I didn't mean to disrespect the House. Maybe it's my lack of familiarity with your rules. My apologies, Chair.
Your apologies are accepted.
Thank you, Chair, for the protection. Rule 20, Honorable Chair, bars presentation of new evidence. Evidence can be by way of an affidavit or a witness being produced for the very first time. We have 4 new witnesses being presented before you today that did not form part of the proceedings at the county assembly. We are interacting with their sentiments and their aversions for the very first time during these proceedings. It's only fair that the governor is given an opportunity to rebut to any information that is being introduced for the very first time. It is on that basis that we are seeking humbly to be allowed to put in an affidavit that has already been filed and served. Counsel is admitting that he has gone through the affidavit. In fact, he's even quoting the contents of that affidavit. There will be no prejudice of any kind if we are allowed to rely on that affidavit. On the video we are seeking to produce, it is actually mentioned in our affidavit. It forms part of our documents and materials to be relied upon, only that it was omitted to be uploaded inadvertently. It's only fair that we are given that opportunity, but my learned friend, Mr. Mwangi, has 1 or 2 issues that he wants to rebut on. Thank you, Chair.
Chair, my learned friend has addressed all the issues, save to give comfort to the chair. The team for the county assembly has clearly indicated they have gone through the evidentiary materials and they have found nothing in those materials. If there is nothing, then they should allow us to use the evidentiary materials that we have brought before this committee. Honorable Chair, aspersions have been cast on the merits of those affidavits. This is not the time. They wait for the hearing. The witnesses will be here for cross-examination. They will have their day, Your Honor. I honorably and humbly pray that you allow us to rely on those statements. Mistakes are always made, and human is to error. We inadvertently left out those materials, and when you look at the index in our bundle, we have referred to those affidavits. The fact that it was inadvertence, we should not be punished, Your Honor, for being human. We pray that you allow those affidavits. Thank you.
So, Counsel for the County Assembly, while you were speaking the first time, senators were not listening to you because you had not been given the mic. Now this is the time for you to respond, finally. And as you do, we would be happy if you could tell us if you are aware of Rule 20.
So, Chair, for your guidance, do you require me to repeat my entire objection as I had put it?